Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And today I have a great topic for you today. So that topic is how to apply for the green card even after divorce from a U.S. citizen or a legal permanent resident. Yes, that's possible under certain circumstances, and I'm going to talk to you about some of those ways. Now, in the case that you got divorced from a U.S. citizen or legal permanent resident because you were mistreated, and now you're still undocumented, you're still in need of a way to work, a way to get legal status, but you are now divorced, so you feel like the spouse may not be the way to go anymore because you're divorced. Well, not true. If you're in a situation where that spouse mistreated you and then you got the divorce, you could still apply on your own without involving that ex-spouse. So this is not just about applying for permanent resident based on a current spouse, but may also apply in the case that that spouse mistreated you. It could have been verbally, could have been mentally, could have been emotionally, could have been financially, and could have been physical. But keep in mind that physical abuse, physical mistreatment is not a requirement for this, as long as you show that there was some form of abuse or extreme cruelty. Then you could qualify for this. And that's where my job comes in as an attorney, to guide my clients who have been through an ordeal like this through the process successfully. But I'm here to tell you that that is absolutely possible, and you should explore this option. Now, one very important detail that I need to let you know, that's the clock is ticking. There is a deadline. Once you have finalized your divorce, there is a deadline involved to apply. And if you wait too long, you could miss the opportunity to apply for your work permit, apply for your green card on your own. This is 2 years. So you have up to 2 years after the divorce to apply for this. You should not be waiting last minute, though. This takes time to prepare this type of petition. And so you don't want to be waiting until, sitting here saying, oh, 2 years, I have 2 years after the divorce to file for this. No, you want to make sure you treat this with urgency and act now to get your petition in, to avoid any possibilities of anything happening that could prevent you from applying and disqualifying you, because you have up to 2 years. So at the time that you file this petition, you must be divorced for less than 2 years to get this. Now, the spouse has to be a U.S. citizen or a legal permanent resident. So this is not just for spouses of U.S. citizens, but this is spouses, so in this case, ex-spouses of permanent residents as well. And the process right now is on the same timeline. That's not always the case. Spouses of permanent residents or ex-spouses of permanent residents would have to wait, and there used to be a wait list. But that is not the case right now. That could always change, and that's where it's very important to go ahead and make sure you explore this option. If you're divorced from a U.S. citizen or legal permanent resident spouse who mistreated you in any way, they were intentionally cruel towards you, they were verbally abusive, they were emotionally abusive, they were controlling, they were financially abusive, they took all your money, they stopped you from working, they took all your money when you did work. These all qualify for this form of relief. Now, let me tell you what you can get with this. Once we confirm you qualify, we get to work to get your applications in, of course, with all the evidence, because this is not just about filling out forms. This is also about completing evidence, putting a good application together, and also drafting a legal memo so that the officers can get a summary of what happened in your case and how that qualifies you for this form of relief. But I can tell you that it is an empowering form of relief, and it is very much possible for you. This does not have to involve the police. This does not have to involve pictures or videos, video evidence of anything, anything that occurred. It does not. Any credible evidence and that means believable evidence could qualify you here. And that's where I come in as the attorney, is I just want you to know that you should explore this option. You should learn whether you qualify. I do consultations with individuals to provide them legal advice and determine whether you qualify. And then we get straight to work for our clients. We do the heavy lifting to get you to the end of the process. You can always go to the link in the profile, the link in the About Us page on YouTube to see the website. There are so many different ways to schedule that consultation. Convenient ways. You can go to the Contact Us page on the website and you can schedule your own appointment. You don't even have to call us. You can schedule. You can call if you need assistance or you would like someone to schedule it for you. We're available up until 6:30 p.m. to do that for you. So different ways for us to help you. Now let's talk about what you're going to get. What do you get once we know you qualify? What do you get? So we apply for our clients so we apply for your first, we make sure we submit what's called a VAWA petition, and that's going to be the basis of how you're going to qualify for the green card. But at the same time we're filing that petition, we're also able to apply for the green card through adjustment of status, apply for the work permit. The work permit is you're able to get the work permit while you're here in the U.S. You're able to get a travel document that would allow you to continue to travel. But now traveling is a case-by-case basis. So whenever my clients do get the travel document, we talk about the risk factors involved with them traveling, but the point is you get a travel document that does allow you to leave leave the country and return if needs be. And then you get the ability to stay here in the United States. So even though you may have been mistreated, subjected to extreme cruelty by this ex-spouse, this U.S. citizen or legal permanent resident, you can still qualify, even if you're out of status, even if you cross the border without permission, even if you've had other issues in your background that render you inadmissible. Guess what? This is still an option for you. So it is one of those options that they keep open for all sorts of situations, not just for people with legal status, not just for people that came in with a visa. It's for individuals. The basis of this should be, were you mistreated? Of course, we look at other requirements, but this, if you were mistreated, the rule of thumb here, get legal advice. You can always call, schedule that appointment, and we can get started on your case. Now that I have said my piece here about applying for the green card, even after divorce from a U.S. citizen or a green card holder, to get your status here, to get your work permit, and to get your green card, I want to get your questions. Now, I want to add this can be done in 2.5 years. That's the processing time right now. It's about 2.5 years. Keep in mind, those processing times may get faster, and they could always change, and go in the other direction. But around 2.5 years is what you should expect. We do the heavy lifting to get our clients to the end of the process. And my representation is very, very holistic. When I say holistic, I don't do piecemeal representation of my clients. I represent my clients from the beginning to the end. I'm there for them every step of the way. And so that is very reassuring for clients, especially if you're in a situation where you're left alone. you're left in a vulnerable situation by that ex-spouse. Also, this is for men and this is for women. And this is for different types of marriages, not just a heterosexual marriage, but also it could be a gay marriage, same-sex marriage. It doesn't, there is nothing that limits who can apply for this, just that you have to be, and then keep in mind, there are other relationships. I'm not covering those today. Those I'm going to for this entire week, I'm going to be elaborating on this. Who can qualify? Parents can qualify. Children can qualify for this form of relief. In these types of parent-child relationships qualify. Stepchild-parent relationships qualify. Adopted child-parent relationships qualify. So I will touch on those later this week, but I want you to know that different relationships qualify for this. Different genders qualify for this, not just women. Now, let's go to your questions. Hi there, Jules. So nice to see you. Thanks for joining. All right. Alita, thanks so much for sharing the live. I appreciate it. Thanks for the love as well. How can I speed up an I-130? So there are ways to ask for it to be expedited if you have a proper basis for it. And it really is up to it's based on the discretion. That means it's really up to the USCIS officer who's evaluating your need for it to be sped up. It's up to the USCIS. But it could be based on a humanitarian need, could be based on maybe there's an economic loss to yourself or others that you can show. If there was a mistake that they made on their end that caused the process to get longer, these are bases to apply for it to be sped up. And imagine humanitarian could mean anything from a natural disaster, maybe in another country. It could be that the permanent residence or the approval of the I-130 will make a big difference in the life of someone else. If someone is in the hospital, there's a sickness and the relative needs to get back quickly. Good afternoon. My husband had a deadline to submit some documents in order for a decision to be made on his I-485 case. How long after the deadline date will he get an answer? So there's no way to say that. It's really based on what problem, what they were asking for, and in some cases, they may not even respond to the request for evidence. They may just move the process along. So where I like to state your expectations regarding a response for the RFE is with the affidavit of support. So once you submit an affidavit of support, I like to tell my clients no news is good news, in that if they are not sending a letter in the mail saying request for evidence again, it means that they have accepted the improved affidavit of support and they're moving right along. Chances are it's going to be the next step in the process. However, if it's something else that they wanted, then a response to that is going to depend on what did their response look like, and what kind of information they're asking for. Good evening. How are you? I'm good. Thank you. So how can you speed up the I-130? I did say that previously. What if you have an asylum case, but later you married a U.S. citizen? Can you do a change of status? So it depends. I don't know. Are you in court? If you filed an asylum case, but now you're married, if this is what's called an affirmative asylum case, you may be able to move forward with a marriage-based process at the same time, and whichever one gets processed first will be great. Especially if you get an approval in one of them. But if you're in court and that asylum case is moving through the court, then that's going to be a whole other process. So it's J for real. That's where it's important to get legal advice and representation, because this live is not enough for you to get a proper answer. Can a pause case affect your immigration case? So if it's a paused criminal case, yes, it could very well affect it, because they may want to see that you've had a final decision in a criminal case before they'll move forward with that decision. But that's a possibility. I don't know what is it, a traffic ticket? What's the extent of that case? And if there is a case, you should definitely get legal advice, because you want to be represented when it comes to criminal issues, for sure. How long after a date to submit documents will I get an answer back? Husband had a deadline. Okay, so I answered that. So I had to submit a new medical form. The old one was expired. He went in for his green card interview. Okay, so it could be a few weeks or a couple months. And if it's a medical, then, it may be a few weeks. But I can't tell you for sure because I'm not the attorney on the case. Now, I do want to take pause for a minute to say that while I am an attorney here, I am not giving legal advice, personal legal advice to you. I'm giving you general information that's meant to educate you, empower you. But when it comes on to taking actual steps, that's where it's important to get that consultation. You can go to the link in the profile to get that done. All right. How long does it take to get a green card if married to a citizen? So it could take now it depends on where that immigrant spouse is. Are they outside of the country? Are they in the country? When you're in the country and you're going through what's called the adjustment of status process, you're looking at about 5.5 months. When you're outside of the country, then you could be looking at over a year, just because the consulates are a little backed up right now. I shouldn't even say a little, they are a lot backed up. And because of that, they're taking a while. What is the processing time for the F2B? So about 5 to 7 years. F2B is the relative, so the son or daughter over 21 or over and unmarried of a green card holder. Can someone apply for a Canada visa on H2B visa in the USA? That I'm not a Canadian immigration attorney, so you'll have to refer to the Canadian Embassy for their requirements. How long does the I-130 take? I'm seeing about 9 months to a year. Let's see here. My grandson, dad, married U.S. citizen, but he's a deportee. Can the stepmom still file for his son? My grandson, they're living in Jamaica. That is definitely a possibility, Joe McCall. Now, step parents can file for their stepchildren in a separate process. So yeah, that's a possibility, definitely. And your grandson's dad, the U.S. citizen that's married to your grandson's dad, may be able to apply for the spouse who was a deportee. There are ways to get around being previously deported, but it depends on what they were deported for. But that's where it's important to get the consultation and make sure you're following through to get the legal advice you need to make decisions, because it could very well be possible to apply for permanent residence even after deportation. It may require a waiver, maybe not, may not even require a waiver afterwards. All right. So my husband is in Guatemala and the case is on hold until he goes back to the USA. Okay, so it seems a little more complex here, and you would have to get legal advice and representation. Go to the link in the profile. So Marcy, so I see in New York. I'm not sure, Marcy. I don't see the rest of your comment. I'm just seeing New York in New York. So I'm going to note here, since I see New York, I want to let you know that I represent clients in all 50 states and around the globe. I have my clients all over the world. That's the beauty of immigration law and being an immigration attorney, is I can represent clients all over. I represent clients before the USCIS, before immigration courts, before the National Visa Center. and before U.S. embassies all over the world. So no matter where you are, I can assist. What is the terms order in BIA decision? So when you're it with the BIA decision, it sounds like there was an appeal, and I don't know what you're referring to, in the decision. This either they affirmed it or if they affirmed it or they went ahead and reversed it and repealed it back. So I don't know which one, what happened in the case. I have a problem. My filing went in before I got married. What if they're ready for me? Would it stop me? Definitely get legal advice. I'm not. If you got married and you're in a category showing as unmarried, and now you're married, yes, it could very well disqualify you. So get legal advice. If your mother is a U.S. citizen and she sponsors you and you're married, how long is it going to take? Around 12 years. You're welcome, Jewel Maka. It's nice to see you again. My mom put in file before we married. So if she put it in before you're married, so you are the unmarried child of a U.S. citizen, now you're married, that's going to change. That's definitely going to change it. If your mom is a permanent resident, that kicks you out completely because you don't qualify as a married child of a permanent resident. But make sure you check. Remember that even though I am a U.S. immigration attorney, as an ethical attorney, as a careful attorney, I cannot give legal advice directly to you. And so it's important before you take any actions or you come to any conclusions that you get specific legal advice in a personal consultation. You can always schedule one by going to the link in the profile. 28 years in the US, my wife is a citizen, 15 years married, but I have a final order of deportation. That could be dealt with. There are ways to fix that situation. It is complex, but you can get that fixed. There are ways to get it done. So when you have an order of deportation, sometimes it just depends on what the order of deportation was, what happened in your case, what are the facts. But in some cases, we can go ahead and revisit that order of deportation and get the case reopened for them to now consider the marriage. So I urge you to go ahead and get representation. You can always call, schedule the consultation, and we can look at a solution. But there are ways to fix this situation. If my mom sponsors me as an F2B, how long does it take? I'd say 5 to 7 years. What about domestic violence? Arrested, case been dropped. So D Tagay, that if you're talking about it depends on what happened, but if the case was dropped, there's no conviction. I would want to know how are you applying? Are you applying for VAWA, which I came on and talked about? There are ways to present this to show that if this was related to the abuse, or we could apply for a waiver if necessary. It just depends on the facts in your case. If it was dropped or there was no conviction, there may not even be a requirement for a waiver. You may not be inadmissible. So get that legal advice and representation. Go to the link in the profile. It was returned to the field local office by BIA. So if it was, I would have to read that order. I'm not sure what is in the order, what's the basis for it to be returned, but it really depends. How often can you travel on a green card? Now, you just don't want to be outside of the US for more than 6 months. I would say 6 months is pushing it, and because if you travel outside of the US for more than 6 months, it could affect your ability to get citizenship after a while. What if you found out your wife, the citizen, is cheating? How to prove it to get VAWA? So there are ways to do this. However, how we present this proof is going to depend on your particular situation, your facts. This is really a case-by-case basis. So this is where it's important to get in touch and let's talk about it and get started. And Dita Gay, you already did the interview. That's fine. Now, if you are in a situation where you have done the interview, and now I don't know what your situation is. I don't know what application you have pending. It depends. So if you're going through a marriage-based process, you already did the interview, then yes, the way the interview went could very well affect everything. That's why I say it's important to have representation at the interview. If you were being mistreated, and there are solutions here to move forward in your process separately from that abusive spouse or even ex-spouse. How can you travel using a 2-year green card? You can travel. You're a permanent resident. When you have a 2-year green card, you can travel outside of the US. There's nothing restricting you from traveling, except just don't be outside of the country for, over 6 months at a time. And I it's pushing it to be outside of the country for 6 months. I am having family issues in my home. Country traveled twice already for 2022. Can I travel again? I wouldn't be able to tell you personally because I don't know what your situation is. Good day. I'm married to someone in Jamaica. I filed for him and his son. However, I found out he's cheating. So I filed for divorce and a letter to immigration. What's the next step? So I wouldn't be able to tell you just because I am not your immigration attorney. Get in touch with an immigration attorney. I also, while in cases where my clients may be in a situation like this, my US citizen clients, I can advise them. I'm not really in the business of just advising about how to withdraw petitions. What's the cost of the consultation? So this is going to be my final answer. I am aiming to be back tomorrow at the same time where we can continue to have a good conversation. For the rest of this week, I'm going to be talking about VAWA, how to empower yourself, get a green card, get your work permit, get stable through the VAWA process. So this whole week I'll be talking about it. Today I talked about how ex-spouses of US citizens, that means you're divorced and you were the ex-spouse or you are the ex-spouse of a citizen or green card holder, how you can go ahead and still get the green card. Even though they're not in the picture. This process is confidential and it does not at all involve the spouse. So I'm married to a citizen and it's time to file for your citizenship and he's nowhere. Get legal advice. That's more complex and you want to make sure you're covered there. Now, what's the cost of the consultation? It's $150 for up to 1 hour. It's well worth your time and money because you do get detailed legal advice throughout this. It's up to 1 hour and I really sift through your facts. This is not just something I glaze over. I sift through everything to make sure you qualify, make sure everything is right, confirm you qualify, and then we get started on your case. All right, so I'm going to head out. I will be back tomorrow, so go ahead and look out for me tomorrow. If you would like to schedule a consultation with me, go ahead and do that by going to the link in the profile. It's going to take you to the website where you'll see all the ways that you can get in touch with me to schedule that consultation. All right, have a great evening. Now, I am heading on over to Instagram. On Instagram, you will see it's The Immigration Attorney. You can follow me there to continue to get information. I have many posts that I do. I do lives here, but I do the posts on Instagram. So go ahead and schedule. You can go ahead, join me there, follow me there to see the content that I release throughout the day. Have a great evening, everyone. I'll see you tomorrow. Bye-bye.